to pay attention to. Now, let me start off by saying that the Constitution is a living, breathing aspect of our lives, albeit that it was recorded in our independence constitution and then in our republican constitution. The fact is that the Constitution is always speaking. The fact is that our understanding of all of our laws in Trinidad and Tobago must be read and understood in the context of what our Constitution says. Our Constitution provides the right for due process. It provides for certain fundamental human rights set out in Section 4. It provides for certain things that Parliament can or cannot do in Section 5. And it provides in Section 13 of the Constitution that we must ensure that laws which affect our fundamental human rights are not only passed with the necessary special majorities prescribed by Section 13 or Section 54 of the Constitution, be they a 3/5 majority, a 2/3 majority, or a 3/4 majority, but that these laws must be proportionate and reasonable in a society such as Trinidad and Tobago. Yesterday, the media reached out to me in relation to a significant development in our law, and that is the judgment coming from the panel headed by the Honorable Chief Justice, Mr. Justice of Appeal Ivor Archie, in the case of Akili Charles. This matter, which I have received many requests for explanation and the state's perspective on, is one of the matters that I come to speak to the nation about today. And permit me, within the boundaries of what is proper, to address the many concerns raised by so many people in the media. So the Akili Charles matter is a case that came before our High Court and Court of Appeal. It's a matter where someone was charged with murder. The matter did not proceed as witnesses were no longer available, and that person, who had spent 9 years on remand, brought a constitutional claim challenging the fact that our Bail Act currently says that people who are charged with the offense of murder, people who are before the court on charges for murder, do not have, by virtue of the Bail Act, the right to access bail. That's set out in Section 5 of the Bail Act, and it is referred to in the schedule to the Bail Act. The matter which came before the High Court was determined, and the judge at that level indicated that the Bail Act was in fact constitutional, largely because the judge said that the law was saved law. Now, in our Constitution, Section 6 of our Constitution clearly sets out what we call the Savings Law Clause. That Savings Law Clause is the one that says all laws that existed prior to Independence Constitution 1962 and our Republican Constitution in 1976, those laws that existed at the time of the Constitution are saved laws. The leading case on saved laws is a Privy Council judgment, which we commonly refer to as the Matthews case. In the Matthews case, the issue of the mandatory death sentence was considered. The argument was that the death sentence is cruel and unusual punishment. The argument in the Matthews case also involved the fact that it was a mandatory sentence that we have set out in our law, our Offences Against Persons Act. And the challenge came up in Matthews as to whether, in fact, Trinidad and Tobago could look at the position of a court being obliged to say you shall hang if you are found guilty of murder, not impose any other sentence other than the sentence of death. And in the Matthews case, a large panel of 9 Privy Councillors sat down and considered what the Constitution of Trinidad and Tobago had to say and whether this mandatory death sentence, which existed in our laws long before independence and republicanism, could still stand as constitutional. Matthews, in fact, said, even though the death penalty is mandatory, even though the death penalty is cruel and unusual punishment, Matthews went on to say, the Privy Council, all 9 judges went on to say, that because the Constitution of Trinidad and Tobago must be read as the Constitution of Trinidad and Tobago, and because there is a provision in Section 6 that saves the law, even though it was cruel and unusual, because it existed before independence and republicanism, it still is good law. Now, that Matthews case, in fact, reversed a decision coming out of the Privy Council in 2003, 2004. It's a case called Rudal. And therefore, the leading case on whether law is saved or not, even though it is offensive to fundamental human rights, is the Matthews case. Jump back into the Akili Charles case. The Honorable Chief Justice, in a very important and landmark decision, delivered the judgment of the panel comprising Madam Justice of Appeal Miradine Armorer and Mr. Justice of Appeal Malcolm Holdip. And in that case, the Honorable Court concluded that there is a right to access bail, even though the 1994 Bail Act says that you cannot get bail for the offense of murder if you're on a charge for murder. The court, in its reasoning, looked at several issues. Firstly, whether the 1994 Bail Act was saved law, because our Constitution allows a restatement of law after independence, after republicanism. In other words, then, if something has been saved, the Constitution allows you to reformulate it, provided that you're not materially changing that law in a new law that comes after republicanism. And the court held that Section 5 of the Bail Act, which is the section that prohibits a court from considering the issue of bail, the court held that that was in fact not saved law. The court also looked at the issue of the separation of powers, and in looking at the separation of powers, held that it was fundamentally included in all aspects of our Constitution, in particular Section 1 of the Constitution, etc. And the court held that the separation of powers was infringed, that it is improper in a society such as Trinidad and Tobago, looking at Section 13 of our Constitution, that it is improper, it is unreasonable in a society such as Trinidad and Tobago for the court to be excluded from considering a matter such as bail, particularly where bail is referred to as a matter in the Constitution, particularly where we have the concept of habeas corpus, where you can be brought before the court to a judge for the issue of bail to be considered. So the Court of Appeal, in delivering its judgment, expressly acknowledged the fact that ultimately this issue of whether bail can be denied, consideration for bail can be denied, courts can be put outside of that consideration, that issue is ultimately a matter for the Privy Council, referred to in the judgment as the apex court. Now, I bring this to your attention because the inundation of calls have started. Indeed, I can report that the DPP's office and the TTPS have already reached out, and that the Attorney General's office is being asked whether we will appeal the matter, and I wish to indicate that we are bound to appeal the Akili Charles judgment, and we are bound to take it to the Privy Council. These were plainly stated to the Court of Appeal, and the Court of Appeal recognized that and indeed gave directions for the fast tracking of the application for leave to go to the Privy Council. All parties agreed with that approach. Secondly, numerous entities have already reported that persons are prepared to move to the court now, to our local courts, to seek bail applications for persons who are in remand. Now, I should tell the nation statistically that there are 2,410 people in remand. And of that number, roughly 1,000, close to 200 persons are there for the charge of murder. 446 are at the magistrate's court, 695 are at the High Court, and the rest are at the Court of Appeal or Privy Council in terms of appeals that are ongoing, obviously at the Privy Council post-conviction and at the Court of Appeal post-conviction. So we are looking at close to 1,200 persons. And in considering the number of questions that have come to the state and to the Office of the Attorney General, it is imperative for me to indicate that we have asked the Court of Appeal to suspend its order. Now, permit me to touch on that. It is a very unusual thing to ask a court that has determined a constitutional issue to suspend its order. Most recently, that was done in a case of Diane Jamili Hadid, where there was a challenge as to the Legal Profession Act and persons being allowed in certain circumstances to practice law. And there is precedent in our country for a suspension of a constitutional declaration. However, it is an unusual thing. I'm pleased to inform that the Chief Justice, there's an order that has been issued yesterday, effectively suspending the effect of that judgment given yesterday. That suspension has come on the basis of an application which attorneys at law for the Attorney General, that is Mr. Fayed Hussein, made to the court. And when we look to that particular order, permit me to say that the order specifically says, it's from the Court of Appeal, that even though the appeal is allowed, the respondent, that is the state, it is also ordered that the respondent defendant's application for conditional leave to appeal to the Privy Council and for a stay or suspension of the operation of this order be filed on or before the 21st of February 2022. Parties are to file and exchange their written submissions and authorities on issues of a stay or suspension on or before the 27th of February 2022, and leave is granted to the respondent, that is the Attorney General, defendant, to file an affidavit with respect to the resources available to the state in support of their application for stay, and I'll explain that in a moment, and that the hearing for that application for conditional leave to the Privy Council and for the stay is fixed for the 3rd of March 2022. The Honourable Chief Justice specifically provided in the order for an interim or bridging order and granted the suspension of the operation of the order until the 3rd of March 2022. So, in respect of the number of applications, a number of inquiries that the Office of the Attorney General, the DPP's office, the Trinidad and Tobago Police Service, etc., have been receiving in respect of the fact that we've got close to 1,200 people in remand on the charge of murder, I am obliged to inform that the order of the Court of Appeal has been bridged, has been suspended until the 3rd of March 2022. That means that no person can apply to the court in light of this bridging suspension until the court considers the matter and indeed makes a determination after the hearing on the 3rd of March 2022. I am obliged to inform that the state will be inviting the judiciary to consider the further suspension of its declaration on the constitutional issues surrounding the Bail Act. The state will be doing that because the logistics of an application for bail require a number of administrative steps. There are matters of antecedents, that is, the persons who are coming before the court, what is their history, what is the nature of their criminal record, if any, what are the considerations and risk factors to be lined up in looking at a bail application, the logistics of where they are, where witnesses are, who is at prejudice, who is not. All of these are fairly complicated and very important steps for the state to be ready for. I must remind that the Constitution of the Republic of Trinidad and Tobago allows for, our laws allow for what is called habeas corpus, where you are brought before the court and you are presented by an application where the party who's seeking habeas corpus tells the court, well, tell me why I should be further detained. Let me go. So we not only must contemplate the administrative steps in a bail application under the Bail Act, we must also contemplate the constitutional claims that can arise, and we must, in that regard, contemplate the writ of habeas corpus, applications directly to the High Court where persons are going to ask for their bail to be considered and their further detention to be considered. Now, it is extremely important to understand, with the declaration of unconstitutionality of the Bail Act, that is where the prohibition against the court considering bail has been treated with, the Court of Appeal having said that Section 5.1 of the Bail Act is unconstitutional, it was not saved law. It means that once that right goes into effect on the basis of that declaration, when the declaration is no longer suspended, rights accrue. And those rights also include the ability for persons to ask for damages for breach of their constitutional rights. It is a very important concept to understand that every bail application must be considered on its own. There's no class action in that regard. We can take some guidance from a very important Privy Council case as it dealt with the privilege of pardon. It's a case called Lendor, and in Lendor, the Privy Council certainly said that each and every application must be considered, in this case for pardon, by the Mercy Committee, the Advisory Committee, on a case-by-case basis. They cannot be considered in a group context. So even though the law is clear that bail applications must be considered one by one, it is important to recognize that the state of the Republic of Trinidad and Tobago can be the subject of constitutional claim, and in particular claim in respect of damages for failure to adhere to the principles now set by the Court of Appeal. If we treat with the judgment itself, and I dare say that I'm treating with this issue very carefully now, because there is propriety that must be balanced here. As Attorney General and Minister of Legal Affairs, I must be very careful not to overspeak in relation to the matters before the court. I respect fundamentally the decision and determinations of our courts, in particular the Court of Appeal, but insofar as we have been inundated by issues, inundated by questions between yesterday and today, I'm obliged to set out a few parameters. The state's position is that the Constitution always speaks. The state's position is that it is entirely open, as the Court of Appeal has done, to consider this issue and to rule as it has. There are two views on the table. On the one hand, there is the view held by Mr. Anand Ramlogan, who acted for Mr. Akili Charles, and the Law Association, which was represented by Mr. Douglas Mendez, Senior Counsel. On the one hand, the view is that the Bail Act is unconstitutional as it relates to Section 5.1, that it is not saved law, that it offends the separation of powers, because the court should always have the ability to consider somebody's detention, particularly because the Constitution speaks to the right to bail, etc., if you look at Section 5. So there's that view. There is, of course, the peculiarity of the fact that Mr. Ramlogan acted as an Attorney General of the Republic of Trinidad and Tobago, and that the Hansard record is replete with his submissions upholding the constitutionality of the very Bail Act that he has now challenged in court. Please understand, I make no complaint of Mr. Ramlogan as an attorney at law, carrying out the duties on behalf of his client. Indeed, the law often changes, and what is considered to be law today can be viewed, because of the living operation of the Constitution, to have changed. But I have received a number of questions as to my point of view in the circumstance that Mr. Ramlogan finds, because if you look to the amendments in 2010, the amendments in 2013, in 2014, all piloted by Mr. Ramlogan, all of them uphold the fact that the point of view expressed by him is that the Bail Act is constitutional and that there should be further restrictions on bail and that the court should be excluded. I think I can say no more than that. I've addressed that issue because I've been asked the issue on multiple occasions between yesterday and today. In relation to the Akili Charles matter, it's very important for the population to be aware of another case. The other case that I'm referring to right now is a matter that we are awaiting the judgment of the Privy Council on. That is the matter commonly referred to as Chandler. In the Chandler matter, the Matthews decision is being revisited. It's being asked to be revisited. Before the Privy Council, in the Chandler matter, the question as to whether the mandatory death penalty is in fact still saved law has come back before the Privy Council. So in very simple terms, the Privy Council is being asked to consider Matthews. Remember, Matthews reversed a case called Rudal. Rudal held that the mandatory death penalty in Trinidad and Tobago was not saved law. Matthews reversed that and said the mandatory death penalty is saved law because the Trinidad and Tobago Constitution must be read as it is written. And in the Chandler case, which we heard in January of this year, an enlarged panel at the Privy Council, again a more than 5 panel sat, and we are awaiting the judgment as to whether Matthews is in fact saved law. That has come about because the CCJ has taken a particular view in a case called Neves. The CCJ has held that something cannot be saved law if at the time of saving it, it was itself unconstitutional, if I put it in very simple terms. So the Chandler decision impacts upon the very decision that we're talking about today, the Akili Charles matter. The Chandler decision is going to consider in very many aspects what is still saved law and what is not. In looking at the second side of Akili Charles, because I just gave you the one side of the Law Association and Mr. Ram Logan, the second aspect of the Akili Charles matter is that since 1917, the law of the Republic of Trinidad and Tobago is that bail has not been permitted for persons on charges of murder. And that, therefore, it is saved law. And even though there is an express collision with the separation of powers and that the court cannot consider by virtue of Section 5.1 the application for bail, even though that is the case, because it is saved law, that it ought to stand. Indeed, the Attorney General's office argued that the Court of Appeal decision delivered by then Chief Justice Clinton Bernard in a case called Sinanan is the proper law, and that there is an important issue to be considered, that you ought not to have bail considered for the cases of murder, persons on charges of murder, because it is saved law. Now, it means, therefore, that Trinidad and Tobago is at a crossroads. We must obviously welcome developments in the law. Again, the Constitution is a living, breathing entity. The issue of whether the Bail Act is saved law or not has been addressed by our Court of Appeal. The Court of Appeal, in its decision, set out the fact that the common law is not the statutory law, and the court went through an historical tracing of what was the statutory law at 1976, and the Court of Appeal felt that magistrates were properly excluded from granting bail, but the Court of Appeal sought to say that judges still were. That issue is going to go before the Privy Council. So let me put it into the following. Number one, the Akili Charles matter has been delivered by the Court of Appeal. Secondly, the Office of the Attorney General will proceed in accordance with the directions and our submissions and directions of the Court of Appeal to apply for leave to go to the Privy Council to seek a review of this matter, largely because the Privy Council, as our apex court, needs to consider what the settled law is. The Court of Appeal has presented a very useful judgment which focuses upon the constitutionality of the Bail Act, whether it is saved law, whether it offends the separation of powers. That matter will be settled by the Privy Council. We will ask for an expedited matter. The issue of saved law is already before the Privy Council. In the Chandler matter, we are awaiting the judgment. If the judgment says that Matthews is no longer the correct approach, it means that the mandatory death sentence will fall. If it upholds the fact that the mandatory death sentence is still good law and that Matthews is still the way the Privy Council interprets our Constitution, then the death penalty will prevail. Those are significant issues for the Republic of Trinidad and Tobago. I can tell you there are 45 people on death row right now, and that clock is marching. So therefore, the mandatory death sentence is an important issue. The issue of the savings law is also in a case called Suraj, now before the Privy Council, and therefore we are at a significant crossroads in terms of where we go. In further summary, there is a suspension, a bridging suspension of the Court of Appeal's declaration. It continues until March 3rd, 2022, when the court will consider and give further rulings if necessary. The state is asking for the Akili Charles Declaration of Constitutionality to be suspended until the Privy Council delivers its decision. We are asking that because the administrative ability to consider 1,200 individual bail applications, the tracing, the witnesses, the risk to society, all of that must be considered in the administrative management. We are also asking for the suspension of the declaration because the risk of the state being obliged to pay damages becomes a real issue, which would have to then be determined by a court of law, and in this case here, possibly 1,200 matters being determined in that regard, and therefore the taxpayers are going to be invited to stand the brunt of this if the law unfolds. It's very unusual, but not without precedent, for an order to be suspended, a constitutional declaration such as this. We are within the boundaries of at least precedent. The Akili Charles matter is going to be affected by the judgment in Chandler, which the Privy Council is yet to deliver. The hearing was completed in January. It's going to be further affected by the Suraj case, which came out of the COVID restrictions and the public health ordinance. So we are at a proper crossroads. Trinidad and Tobago is a very noisy place. There are many issues in circulation in our society, and unfortunately, there is little space to consider some of the larger issues. In terms of crime and security, obviously, the Akili Charles Declaration is a very important case. I have addressed the issue of a previous Attorney General arguing, at least for several years, that the Bail Act is fully constitutional, and then today arriving to say that it is not. I do not make any condemnation of the attorney at law who argued that case, because every attorney at law is entitled to argue a case and their clients are entitled to be represented. I do accept that it is sometimes difficult to accept what we call approbation and reprobation, but I want the population to understand that those are two very different hats that attorney at law occupied. So, ladies and gentlemen, I ask you to focus on what's before us, the constitutional crossroads that we find ourselves in. I'd like to tell you that the Office of the Attorney General has prepared a number of laws as options in the event that the Chandler case goes one way or the other, and as well has considered further amendments to the Bail Act, etc. But this is a very important issue for the people of the Republic of Trinidad and Tobago. My intention today is to not traverse any boundaries that I ought not to cross. I make no complaint or criticism of the judgment of the Court of Appeal. Indeed, the Court of Appeal has allowed us to move to the Privy Council to settle the law. And the judgment, written by Mr. Justice of Appeal, Chief Justice Archie, is very clear that the court contemplated the effect of Chandler, and the court took its time to paint the four corners of the difference between the common law and the statutory law, what was saved or what was not saved, whether there was a separation of powers, whether the rule of law and the Constitution ought to be considered the way it is. So may I stop at this point and invite the questions coming from the media, which I will happily answer as best as I can.
Thank you, AG. We move now into the Q&A segment of today's media conference. Media personnel, you're kindly asked to state your name and media house before posing questions. We will accommodate 2 questions in this round, and if time is permitting, we will accommodate 1 more. We start with Priya Bihari at AZP News.
Good morning, Priya Bihari, AZP News. Good morning to all. AG, my first question, I want to find out what impact you think the Charles case would have in the government thrust in its fight against crime. Recently, you all have passed laws, making certain firearm offenses non-bailable. And now you have people who are accused of murder now being able, have a chance to access bail. How of a strong impact you think this would have in the government's fight against crime? One. My second question has to do maybe with a more overall look against constitutional reform. You've spoken about the Matthews case and the Roda case. Before that, I think the standard was the Pattern Morgan, for years. So there seems to be some sort of uncertainty in the law now. Is there now a case that could be made out for some reform of our laws that would bring some sort of certainty now into it? Thank you.
Thank you for your series of questions. Permit me to perhaps clarify a number of matters. First of all, the law is absolutely clear. Pratt and Morgan is not a decision which treats with saved law or not. Pratt and Morgan says, look, if you're on a charge for murder and you were convicted and you were sentenced to death and you are on death row, Pratt and Morgan says it will become cruel and unusual punishment for you to be on death row without your final appeal being determined within 5 years. So Pratt and Morgan has nothing at all to do with the save law and constitutionality of bail or whether the death penalty is a valid sentence or not. So Pratt and Morgan is, listen, you're on death row for 5 years, you cross 5 years, it's cruel and unusual punishment, commuted to life sentence. That's Pratt and Morgan. In the case of treating with the government's fight against crime, we did not amend the Bail Act to say that you can't get bail without a court considering it for gun charges. What we did is we said, we amended the Bail Act to say, you should be put upon an obligation to say why you are in the exceptional circumstance of getting bail. So we left the discretion of the court. We did that because of a case called Saint Omer and the Justice of Appeal Nolan Barrow and his judgment in relation to that matter, which said that you still have the right to consider bail in a court for those matters. But what we did is we narrowed the gate significantly by saying you must have exceptional reasons why you should get bail, and a court should consider that. In the terms of fight against crime, quite curiously, if you look at string of attorneys general, Keith Sobian, come through Anand Ram Logan on at least 4 occasions in 4 different bills in the parliament, and me. If you look at us, we've all said that this falls down to a balancing of rights. In Ram Logan's case, he was very far along the plank. He was like, it's in his movement of no bail for kidnapping, no bail for anti-gang, where the court was absolutely excluded. He said that the rights of the individual ought to prevail over the rights of the criminal. And in fact, Mr. Ram Logan went on in the Hansard to paint these pictures about the minute somebody comes out of jail, basically everybody's in trouble and criminality will explode. Today, of course, Mr. Ram Logan doesn't seem to have that point of view, but he was wearing 2 different hats, obviously. So In terms of the fight against crime, permit me to just simply remind that if the Court of Appeal's decision stands, if the Privy Council holds that, if there is a lifting of the suspension, the courts are going to have to consider approximately 1,200 bail applications potentially, each one on its own. And the state and preparedness for whether there are criminal charges, the state of the prisoner's condition, whether witnesses are at risk, whether people are going to be in morbid fear or want to resist the application, those are very real circumstances, because there are some very high-profile murderers, alleged murderers, before our courts and who are without bail in prisons. So, again, it is proper that we accept that our judiciary can handle bail applications. The question is going to be whether the system is ready for the bail application to be heard. And inside of that, not only considering the bail application, but will the state be exposed to damages for breach of constitutional rights? And some of that is affected by, and the Chief Justice has put a very important further consideration in the judgment, the issue of delay in trials. Now, whilst the government has engaged in significant reform, more courts, processes, judicial terms and conditions, more judges legislatively, decriminalization of matters, move of matters away. Whilst all of that is going on, the prosecutorial capacity is an important aspect to be considered. So people in this country hear of a lot of reform. The question is whether we feel the effect of reform. And whilst we can accept that there's been significant effect, if you look at the motor vehicle and road traffic arena, where 104,000 cases used to go every year, and now that number is drastically reduced, and we have a 65-year low for road traffic accidents because people face violations. There are real effects from reforms, but the big issue right now is, are we prepared to have matters go before the court to consider bail for people who are alleged to have committed very serious crimes? Remember, Trinidad and Tobago is very different from a number of other countries because we do not have a classification for murder. We don't have murder in the first degree or second degree, where a father came in and saw his child being raped and attacked the person who was raping his child, and the person died and therefore potentially subjected to a charge of murder. Is that the same person as a stone cold killer caught on CCTV camera with a high-powered machine gun mowing down 10 people and killing them? No, they're not. And where we have a classification of murder, that's where bail can or cannot be considered. But other countries where bail is considered that way, there is a classification for murder. Jamaica has a classification for murder. Barbados has a classification for murder. I have drafted classifications for murder, but cannot advance that discussion until I get the Chandler judgment. Because a classification for murder has to involve the save law, because the Offences Against the Persons Act was saved. So that's one potential angle. There's another point of view that says you don't need to look at the constitutionality of Section 6. So that takes me to answering your question about, is there need for constitutional reform? And yes, this country is screaming and crying out for constitutional reform. But constitutional reform of the type that is required will inevitably involve some laws being passed by a 2/3 majority, some by a 3/4 majority, and some by a 3/5 majority. And I dare say the opposition is not prepared to support any form of significant reform if we cannot pass a whistleblowing law, as simple as that is, to allow people the ability to blow a whistle on criminality. If we can't pass the law on evidence, witness anonymity, where we're saying give witnesses the availability for a court to say they shall remain anonymous, as happens in many countries in the Commonwealth. If the opposition won't support laws like that, how do we on earth expect them to support laws of the type that we're talking about? That's a question for societal agitation, because we have made this approach on umpteen occasions, and if you look to the voting record of the opposition, you'll see that it appears to be a no-go.
Thank you, AG. We now move to Joel Brown, TV6 News.
Good morning, Attorney General. first and foremost, in terms of the Privy Council, the government seeking its appeal before the Privy Council, how long does the government expect the Privy Council to begin its proceedings and then make a ruling? Also, in terms of the suspension that you're seeking until the Privy Council delivers its ruling, if the government is unsuccessful in that regard, what are the implications in terms of those persons, as you said, who already are seeking to have applications for bail regarding this matter?
Thank you very much. So let's line up the ducks. The Chandler decision is due to be delivered any point from now on. So we concluded the decision, the arguments in that case in January, and the Privy Council has reserved its judgment. And I can only assume, I've made inquiries of our Privy Council representatives. I've asked for them to knock on the door of the court to indicate when Chandler will be delivered. Chandler is the first duck. Chandler affects in very many ways the arguments that will be presented in the application in the Akili Charles, because they're going to look at this, they're going to provide guidance on the save law in relooking at Matthews. The application for leave to go to the Privy Council comes up on the 3rd of March. The application is also going to be heard simultaneously with our application for a stay or a suspension or continuation of the bridging suspension of the order made in the Court of Appeal. And we're going to ask that so that we can prepare for eventualities. Because the real difficulty in lifting the suspension, from my humble perspective, is that we're going to be inundated on a case-by-case basis with approximately thousands of applications, or 1,200 applications. If that is the case, the question is the prosecutorial arm, the DPP, and the Trinidad and Tobago Police Service, and the Trinidad and Tobago Prison Service, and the Witness Protection Program, are they administratively in possession of all of the factors that are to be considered in resisting a bail application? That is a very large exercise, and therefore, whichever way the Privy Council goes in the Akili Charles matter, at least we would have had the advantage of preparing the administrative structures. I want to remind you that we are at the cusp of abolishing preliminary inquiries, and that is a step which again quickens the pace of justice. We have a public defenders division, we have specialist criminal courts. The Chief Justice has already occupied part of the Tower D courts, that's the waterfront courts, and therefore the retrofitting of the Hall of Justice for Criminal Courts is part and parcel. The jury courts at O'Meara are near completion. So there's a significant amount of administrative work that is going on at the same time. So we're preparing one way or the other. We will invite the Court of Appeal to consider the extension of the suspension of the order in Akili Charles so that we can be administratively ready to consider bail applications or constitutional claims.
We move on next to Rishi Harinanan of Multicultural TV.
Hi, good morning, AG. Nasir. My question is, we hear this matter, and I'm thinking, is the government considering things like house arrest and putting things in place for the classification of murders to make matters like these, simpler to deal with if the ruling from the Privy Council doesn't come back as you may hope it would? And then the other thing is, you said that there is a suspension of these people who may be able to apply for bail now who are there. But would the government then consider holding these matters in abeyance so they could probably start the process just in the eventuality that something would happen? And if you would indulge me just for 1 second, whatever happened with the vaccination policy?
Sure. Nice slip in there on the last point, an important one as well. Can I remind you that house arrest sounds really good, right? We do have an up and running electronic monitoring unit where ankle bracelets can go on as a conditionality of bail. We've amended that law. It's in operation already. But I want to remind you that some of the people who are in remand on charges of bail are alleged to be some of the biggest gang leaders in Trinidad and Tobago, and that they have, in fact, some of them been put into the building 13, as we call it, where they are being excluded from communications, including unlawful communications in the prisons facilitated by certain corrupt entities, which we all know about. And therefore, the question is, are you comfortable with house arrest for those kinds of people? I'm not saying that a court properly instructed and considering all the administrative concerns would ever grant bail in that situation. But I'm saying for us to be ready to resist bail applications, the prosecutors need to be. Now, I need to remind you, the Attorney General is not the DPP's office, is not the Trinidad and Tobago Police Service. So we don't have administrative control over files and preparedness in the criminal law. I am excluded from that by virtue of Section 90 of the Constitution and by virtue of the police powers that the police have under the Police Service Act and other law enforcement agencies. So please do not confuse what a government can do versus what the readiness of the people who are in the system have to do. Our job is to provide the resources. My job is very importantly to connect the dots, because look, albeit we had a very significant event, which was the blackout in Trinidad, I was hard-pressed to find news coverage of the Akili Charles matter and the impact that it would have in society, because obviously there's a competition for large issues in the press. So you asked whether the government would hold in abeyance or suspend. We have no control over that. The government has no control over what goes into abeyance or what does not go into abeyance. If a constitutional right exists, let me give you an example. There was an attorney general in this country who participated in passing a law that says you have to have child rehabilitation centers. Mrs. Kamla Prasad-Bissessar, as the head of the cabinet, proclaimed that law. There were no child rehabilitation centers in existence at the time they proclaimed the law. In fact, a gentleman by the name of Mr. Anand Ram Logan approached the court on a constitutional claim to say that children had the right to go into a child rehabilitation center. They should not be in adult prison, if I could put it that way. And the court was compelled to say, yes, you're right. The court had to watch the attorney cocky eye to say, well, weren't you a part of the government that passed that law? So today you're coming as an attorney to argue a constitutional right, and state has to pay damages when you were the person that didn't have it ready, meaning you, the government. I'm painting that example to tell you that the effect of a constitutional right to access bail, as the Court of Appeal has put into effect in Akili Charles and has now suspended, attracted to that is the issue of damages for breach of your constitutional right to access bail. And attracted to that is also the time frame it takes for that to happen. It's not a forerunner issue, but it is in the envelope of issues, because what is now before us, which we've been working towards, is to ensure that trials get to the front of the pack, because the criminal justice system has to work. And whilst I may know a lot about the structure that is going on, the population doesn't feel it, because seeing is believing. And I could say from now till the cows come home that it's soon to come, and it's soon to come, and I'm confident it's imminent, but people still want to feel that sense of security. So I don't think that there can be any abeyance that the government can treat with. On the issue of the vaccinations, suffice it to say, the Honorable Prime Minister has left to go to a Heads of Government Energy meeting today. The Office of the Attorney General received submissions from a number of stakeholders, which we have factored. The law has been drafted, but that law must be considered in the state and condition of our science. So that is to come before the cabinet, and the Prime Minister will speak to that issue when appropriate. He is gone for a week roughly, and at a very important energy conference in Qatar, and the Prime Minister will speak to those issues, because the team of experts need to sit together with the proposers in law, because the law has to be applied to the circumstances that we are in, or the circumstances that we expect to come at us. Because a variant today may not be a variant tomorrow. So I will leave that to the Honorable Prime Minister to speak to. We have addressed a number of issues in that regard. The issue of liability, the issue of the private sector, the issue of the public sector, the ability to roll it out in separated packages. All of that has been drafted and completed. But now the space for the science to be factored and the direction of the cabinet, as the Prime Minister will speak to, has to happen.
We move now on to Nadaleen Singh of Caribbean Lifestyle Communications.
Good morning, Nadaleen Singh, Caribbean Lifestyle Communications. I just have three small questions. I was wondering, I'm referring in fact to the people who have a murder charge against them in the courts. What happens if the state has to pay out damages for taking away the rights of these people? Now, if the courts rule in favor of them? And then secondly, why isn't precedent present in this scenario? And then thirdly, what does this development do to the confidence that the people would have in the courts in Trinidad?
So let's deal in reverse order with your questions. I don't know how many of you saw a video clip that has been going around, supposedly coming from the prisons. Now, technically, you're not supposed to have a recording device, let alone a phone with a recording device in the prisons. So this video clip that has been circulating, supposedly from the prisons, is one where people were celebrating and chanting, "We get in bail, we get in bail, we get in bail." So let's add up that in terms of confidence. We have laws that say there should be no phones in the prisons. The prisoners didn't walk out and get the phones themselves and come back. So the phones either miraculously appeared in the prisons by magic, by a pigeon, by an aircraft, or somebody brought it in. And there we have, and hence the reason for today's press conference, because we've been inundated by inquiries from people who are worried about confidence, about their safety and security. We've been inundated by people saying there's a large issue and they want to hear more about it, hence my presence before the media today. So in terms of confidence, I think it's a big issue, because the confidence is not the judgment. The judges, the Honorable Chief Justice, must do what they must do as judges. They must interpret the Constitution, they must interpret the law, and they have done that. And I commend them for their job, because it now allows us to go and get the apex court, the Privy Council, to settle the issue. Whether there is a confidence issue, for sure, I think that there are quite a few people who are worried. People who are witnesses in cases will no doubt be very concerned. People who are crying out for justice, people who say that they are innocent and they've been wrongly incarcerated, they are crying out for justice. All of that is part of the equation. In terms of precedent, there is precedent. The Court of Appeal in the Sinanan case, in Mr. Justice of Appeal Chief Justice Bernard, held that the Bail Act was constitutional. The Chief Justice looked at that in the Akili Charles matter and sought to provide a distinguishing point of view, very respectfully put, but that's going to come back up. The precedent is that since 1917, there has been no bail for persons on charges of murder. And the Chief Justice looked at that and said, well, look, don't confuse the common law with the statute. We have to look at what the statutes say. And he went through a very, very, very careful and useful analysis of what the law says in terms of the statutes, right? What is saved law is the common law can't override a statute, is basically the point. You asked about murder charges and if the state, what happens, people on charges before murder, for murder coming before the courts, and if the state has to pay damages. Damages is not an automatic thing. Permit me to clarify that. So, if there is no suspension of the order, the Akili Charles order, then the constitutional right kicks as of when it is set free. So it's currently held down by a bridging suspension. If that suspension comes off, then you have the constitutional right to access bail. People would then have to approach the courts and consider an application for bail under the Bail Act, or they can approach the court under the constitutional structures that we have for habeas corpus. Those are two different routes. They can also, in argument stage, not that this is going to be the result, they can also come forward and say, look, my constitutional rights to access bail are being infringed because it's taken too long, and I have the right to be there. Now, so far, our courts have said that there is a right to justice, but there's no right necessarily to an immediate sense of justice. That is going to be a very large issue for Trinidad to consider, Trinidad and Tobago to consider, as to whether delay is something that infringes the right to a fair trial. It has so far not come to the fore, but it is certainly at the cusp of determination. So all of these tough issues are going to have to be settled, and the only way to settle it, and the best way to settle it, is in a court of law, in this case getting to the apex court, which is the Privy Council, to settle the issue once and for all.
We take our last question from Jewel Brown.
Yes, thank you. I was just wondering, in terms of the issue of, say, those in state protection, for example, state witnesses, how does this impact that aspect of the justice system? And also, just on the matter you had answered earlier from my colleague regarding the legislation for public sector workers, given your answers, it's safe to say, sir, that legislation will not go before the Parliament before the end of this month?
Thank you. So in terms of state and witnesses for the state witness protection, it's a very large issue. This is what I meant by the administrative preparedness for bail applications. Because obviously a prosecutor resisting a bail application would want to say that there's a prejudice to witnesses and the material would have to be put before the courts. Indeed, those are some of the considerations set out in the Bail Act itself, right? The risk of flight, the risk of running away from the court, the risk of harm to potential witnesses or to the administration of justice, etc. So it's a very large issue, and that's why we're going to make our application as robustly as we can to ask the Court of Appeal to consider the extension of the bridging suspension, and ultimately our request is going to be to have it suspended until the determination by the Privy Council. To answer the very important second question that you asked, I have not received the Cabinet's approval for legislation, and that is because the final aspects of legislation were being ironed out at the Office of the Attorney General because of very important submissions that we received from a number of sectors, including the trade unions and the private sector. Some of those issues included liability, which the state is minded to accept, included how are we going to treat with people who are constitutionally protected in terms of terms and conditions. Let me quickly say that that's the Section 136 consideration. People whose conditions can't be changed other than by way of a special majority in the Parliament. We were also considering the factors including the ruling workout of this equation. The effect in the courts also had to be ironed out. Is this going to go to the industrial court? Is it going to go to the High Court? Now, we've worked out and mapped out those positions. And the Prime Minister allowed me the opportunity to settle those issues. Indeed, I've been taking advice from within and outside of the Attorney General's office. And upon the Prime Minister's return to the jurisdiction, I intend to give him the settled versions, the multiple versions that we have. I want to remind that the Prime Minister's ultimate direction and the Cabinet's decision is always informed by the state and science of what we are dealing with. And therefore, the input of the medical teams, the Chief Medical Officer, the World Health Organization, our state of vaccination, acquired vaccination, that is infections versus receiving vaccinations, all of those things are to be considered. In terms of time frame, the Prime Minister had indicated a 1-month extension to the middle of February, whilst he allowed the Attorney General to consult. And that consultation went over that mark, and therefore the result of that went over. The vaccination laws to be contemplated are laws, and therefore the Parliament, if we are to approach the Parliament will have to debate it in both houses of Parliament, and there is no bill before the Parliament. No bill has been approved by the Cabinet yet. You have to understand that the science is not only what is the current science, but what is on the horizon. So the experts are very important in this regard. Is there going to be a version of the virus which is lethal, more lethal, less lethal? What's on the horizon? Because if you look to the other countries that are in a state of relaxation have very high vaccination numbers, very high booster numbers, and very high infection numbers. The other day there was a very important article that came out alluding to a new variant that is yet to be spoken of. So the science is going to inform, because the law is not only the present state and condition of Trinidad and Tobago, but what is around the horizon, and whether you want to be prepared for that in terms of legislation which allows you at least to take a step faster rather than not.
Thank you very much, AG. Ladies and gentlemen, we want to thank you for joining us today at today's media conference. Please remember to wear your mask, wash your hands, and watch your distance. Thank you very much.
This is TTT. Live for local.
Good afternoon, I'm Stacey Ann Providence, and this is your TTT News at noon. The search continues.